let's get started. Kia ora everyone, welcome to MyHR's Understanding Personal Grievances webinar today. Thank you for your patience as we get started. A couple of minutes late, we had a couple of technical challenges getting the Zoom lined up this morning, or this afternoon I should say. So welcome, thank you very much for coming along. I will share my screen in a second and we will get started. Because we didn't have time to do a technical test like we normally do, if you have any issues seeing or hearing me, can you just let me know in the Q&A box? If you can see and hear me fine, that's totally cool. No need to send a message through just if you are having issues so I can troubleshoot as we go. So let me share my screen here and we will get ourselves underway. Cool. So what I'm hoping is you can see a title screen that says Understanding Personal Grievances, and if you can, that is all working perfectly. Let's get into things today. Now, before we get started, as usual, just a bit of housekeeping from me. So today's session is being recorded, which means if you do have questions to ask, just be aware that there will be a copy of that question being asked in a public space. So you're welcome to use the Ask Question Anonymously function if you like. Even though it is being recorded, I do ask that you keep today's discussions confidential. We just want to make sure that we're honouring what it is that people say in the questions that they have. So if this ends up on TikTok later, we might need to have a conversation. Slides, of course, will be supplied afterwards as usual. So if you'd like to take notes during, that's totally cool. Or again, if you need to duck away or answer a phone call, or if you can't stay the whole length of the session, totally fine. You'll have those resources in front of you later to be able to use. Lastly, questions are welcome. If you've come along to one of our webinars before, and we often have some repeat attendees, which I think is the greatest compliment, you'll know that questions really make these sessions come alive with what it is that you're asking or you're keen to know. So you're welcome to pop your questions in as we go along. What I will do is collate all questions and answer them towards the end of the session. So if you want to ask as we go through, that's totally cool. If you want to save your questions until the end, maybe in case I answer them, that's totally fine as well. But we will have plenty of time for questions towards the end of the session today. Now, what I would love to do is a very quick icebreaker before we get started. One, to give you guys some practice at answering questions and using the Q&A function, but also to give me a sense of who's on the call and what it is that you are looking to get out of the session today. What that will do for me is give me a sense as to what examples might be useful, maybe a sense as to which slides or sections of the presentation I should be spending more time on rather than less. So if you can take a second just to let me know your name, whereabouts in the country you're calling from, and what it is you're hoping to learn today, I will pick that up in a couple of minutes. Before we do that though, a little bit about who MyHR is and why we're doing a session about personal grievances. So we were established in 2013 to make HR easy. And we do that by being an outsourced HR provider that covers all employment matters. So we do the proactive stuff around employment agreements, around onboarding and performance reviews, all that cool stuff. We also hang out at what I like to think of as the pointy end of HR, which are things like personal grievances like today's topic, but also restructuring, disciplinaries, trial period terminations, all that kind of stuff as well. So there's not a lot that we haven't seen. The way that we do this is a little bit different. So we have an HR platform, which is your one-stop shop for all sources of HR truth in your business. It's where your employee files live, like a digital filing cabinet. It's where your policies and processes live. And the software also acts as the bridge between yourself and then our team of HR advisors and admins in the background. So not only do you get a software platform that does all of the streamlining and cool stuff that software does, you have an on-call HR team who are there to help you through tricky people matters, to write documents for you, guide you through processes, whatever it is that you need to manage HR in your business, which is what sets us apart. Excitingly, we have offices in Auckland, Christchurch, Sydney, and now Vancouver in Canada. We opened up a branch there earlier this year, and we have a number of Trans-Tasman employees, but of course our NZ businesses are serviced by our NZ team here in Aotearoa. In Sydney, we've got an Australian team over there, and we've got people on the ground in Canada as well. So you won't be calling up and speaking to a call centre, you'll be serviced by someone in your local jurisdiction. In terms of who our clients are, it's a really massive range. So we run the gamut from people with one employee all the way through to about 800 at the moment is our largest. And we cover all industries. So think manufacturing, retail, accommodation, hospitality, professional services. We've got clients that cover the whole spectrum. So again, not a lot that we haven't seen. We're often very well placed to help manage people issues. And as I go through the presentation today, some of those stats will become increasingly clear. Lastly, the way that our billing works is because we're a software as a service business, so a SaaS company, the way that we invoice is you get a monthly fee based on your employee headcount, not based on how much you use us. So if you're a business of 10 people, that might be $2.95 a month. If you call us 20 times because you're dealing with a difficult person that you're taking through a disciplinary process, the next month you might call us twice because you've just got a question about an employment agreement we've written for you. Your billing remains the same. We don't bill you more in the month you use us lots. We don't bill you less in the month that you use us less. It's just a flat fee for you, which makes accessing our services a lot easier than getting a bill in 6-minute increments from your lawyer or your consultant. Back to the icebreaker. Let me pull up our questions and see who it is that we have joining us today. We've got Anna from Tauranga. Kia ora, Anna. Thank you for joining us. Anna is taking on HR responsibilities. This will be a good session for you, Anna. This is Kay. Hi, Kay. Thank you for coming along, located in the Mackenzie region. Nikki from the Faith Place commutes to Auckland for work from Melbourne. Goodness, that's a bit of a commute, Nikki. Thank you for coming along. Deborah from Timaru. Kia ora, Deborah. Thanks for joining us. Deborah is keen to make sure that she's up to date with all requirements to avoid the risk of errors in processes in the future. That's a good reason to be here. Katrina is here. Hey, Katrina, thanks for coming along. An anonymous person is joining us from Christchurch, hoping to get an overview around the PG process, as it's not something that they've had to deal with before. Yeah, you're in exactly the right place for that, Anonymous. Thank you for coming along. We've got Vic from Wellington. Hey, Vic, nice to see you. How are you doing? Thanks for joining us today. Sue from Christchurch is here to get a refresher on PG processes. Keen to know if contractor versus employee status challenge could come through a PG process, or is it handled another way? Great question. We'll have a look at some of the grounds we can raise here. Mike from Resine Paints is here. Kia ora, Mike. Nice to see you. Thank you for coming along. Kyle from Tauranga, hoping to get some ideas on how to explain PGs to your managers. That's a good one. Explaining these processes can be a bit tricky. Amanda, Leslie, Gemma, Debbie, Robin, awesome. We've got heaps of people joining us today. We're at over 104 participants. So thank you. If I didn't get to your name and your location, apologies, but I'm very grateful and pleased that you're here regardless. So let's jump in and get into today's content today and see what it is that we're going to be covering off. So in terms of what to expect today, the first thing we'll do is talk about what a PG is, because that's a good place to start, especially if you haven't dealt with one before. We'll look at responding to a grievance and what's involved there. We'll talk about mediation, because that's often a follow-on once a grievance is raised. We'll take a brief look at the Employment Relations Authority and what that process is like if you haven't managed to resolve the grievance beforehand. We'll talk about records of settlement and where they can be used, how to minimise the risk of a personal grievance, and then have some time for questions before wrapping up at about 5 to 2. The last few webinars we've done have gone over time with the questions towards the end. What I'm going to try and do today and give us a little bit more time for questions so everyone can join us and everyone can stick around until 2. But if we do need to go over time, that's totally cool. I'm happy to be here. If your question has been answered and you don't want to stick around for the overtime questions, that's totally cool. I won't be mean to you if you choose to sign out earlier. So let's talk about what a personal grievance is. Now, some of you on the call will have had them before and some of you won't, but just to be really clear with what we're talking about, a PG is an action an employee can take when there is an employment issue that has not or cannot be resolved. Now, an employment issue could be any number of things. It could be that we as the employer have done something wrong or unfair to our employee. It could be a frustration the employee has about their job or how work is being managed. Basically, the law says because we're in an employment relationship, we first have to try and resolve the issue ourselves. You can go straight to raising a PG if you want to, but most of the time what will need to happen is the employer and the employee have to try and resolve the situation themselves before it gets to the point of raising a PG. But basically, it's the legal mechanism that employees have to address concerns about their employment or about something that's happened during their employment. Now, these, as you would imagine, are governed quite carefully by employment law. So Section 102 of the Employment Relations Act says that employees can raise a personal grievance, and Section 9 deals with a lot of the mechanisms of how PGs are to be raised, including the grounds on which we can raise them. And a PG can be taken against a current or former employer. So you don't have to still be employed by someone to raise a personal grievance with them, but it must be raised within 90 days of the thing occurring that is the problem you're trying to resolve. So if you were dismissed on let's call it the 1st of September, you would have 90 calendar days from the 1st of September to raise your grievance with your ex-employer. Or if the issue only comes to your attention later, for example, if you had your pay changed and you didn't notice for a couple of weeks for whatever reason, as soon as you become aware of the issue, that's when the 90-day clock starts. So a little bit of grace there, depending on whether you are or aren't aware of the thing that is causing the problem. Most of the time, employees are aware of the thing that's causing a problem because it's the promotion they didn't get or the dismissal that they experienced. So you need to raise that PG within 90 days. There are some exceptions here, including if the PG is the sexual harassment, you've got 12 months to raise the grievance there. Or the employer can agree that the employee can raise it outside of the 90 days. Most employers won't agree, but you can choose to. And the other circumstance is if the employee did all the right things but was let down by a lawyer or an advocate or a representative. So if the employee, let's say on day 45, instructed their lawyer to raise a PG with the employer, say the lawyer dropped the ball and forgot to until after the 90 days has passed, the employee hasn't done anything wrong. They've tried to raise it within the time frame. So in most cases, the Employment Relations Authority will say that it's fine for the employee to have raised the PG a bit later. Once you've raised a PG directly with your employer, the employee then has 3 years to raise it in the Employment Relations Authority. So if you have received a PG, you've told the employee to go jump in a lake because you think they've got rubbish claims, that might not be the last you hear of it. There's a 3-year time frame for it to get raised in the Employment Relations Authority, so just something to be aware of there. Lastly, the employee doesn't have to say, I am raising a personal grievance. They don't have to use that specific language. The policy reason is that not all employees are going to be that fluent or that familiar with the language of employment law. We don't want to disadvantage people from raising a claim just because they didn't use the perfect exact language. And it can be in writing, it can be verbal. Most of the time it will be in writing. I think I've maybe seen 1 or 2 PGs that started off verbally. But whatever the way that they communicate it to you, the reason for the PG and the fact that it is clearly a claim that they would like resolved needs to be super clear and super explicit. So an employee can't just say, I'm mad at you and have that count as a PG. That would be unreasonable. They do have to be quite clear about the reasons they believe that they have a claim and the reasons that they're raising this. So what are the grounds on which an employee can raise a PG? Now, there are multiple categories that a PG can be raised under. Some of them are quite broad and some of them are quite narrow, as we'll see. The 2 most common are where an employee is alleging that they have experienced an unjustified disadvantage in their employment. So their employer has done something unfairly or in a way that has caused the employee a disadvantage and that disadvantage was foreseeable based on the action of the employer. Or unjustified dismissal. Basically, they've been fired and they don't agree with the reasons why, or they don't agree with the process that led to them getting fired. Other categories very quickly are discrimination, sexual or racial harassment. There's a specific one around if the employer has agreed that there will be some continuity of employment obligations not met when someone is restructured. Certain clauses in the employment agreement don't meet legal requirements. If an employee's made a protected disclosure and then they've experienced retaliation from the employer, that's a specific grounds for a grievance. If there's been any unfair treatment related to family violence or refusing to work in certain circumstances, duress related to membership or not of a union or another employee body, and if they're a retail employee who is either forced to work Easter Sunday or who doesn't want to work it and is kind of punished unfairly. It's obviously a very specific category for a grievance, but it is there. If an employee refuses to work under certain circumstances, there's a PG claim there. Anything to do with being unfairly required to do something related to the health and safety that breaches the Health and Safety at Work Act. And if they participate in reserve forces services or training, or if jury service and then their employment isn't protected, that's a category as well. Oh, that's a very long list to go through. The majority of the PGs that we see are for unjustified disadvantage and unjustified dismissal. Those are the two most common by far. Unjustified disadvantage is massively broad because it relates to anything where the employee experienced an adverse outcome that wasn't fair, basically. So most of the time that will be to do with pay, or it'll be to do with an outcome of a process like a disciplinary or a restructure, but not always. It's a pretty broad category. Unjustified dismissal, obviously a bit narrower because we're talking specifically about a dismissal here, but otherwise these are the categories that an employee can raise a PG for. Cool. Let's jump forward. If you do raise a PG, or if a PG is raised against you, what are the potential consequences, financial or otherwise, from that PG being raised? Let's start with financial, because this is the one people tend to be most concerned about. Financial compensation can include a claim for lost wages. So if they were fired unfairly and it took them 3 months to find a new job, they can claim that you owe them 3 months of lost wages, because if you hadn't fired them, they wouldn't have been without income for those 3 months. They can ask for compensation for basically hurt and humiliation or injury to the feelings of the employee. This is basically you were the dickhead, or you made a dickhead decision and I'm asking for some money because that decision kind of hurt my feelings. And they can also ask for costs to be awarded, on the argument that if you hadn't chosen to do the bad thing that resulted in them losing their job or being disadvantaged against, they wouldn't have had to have hired a lawyer, hired an advocate, any of that kind of stuff. So costs can come into it. They can also ask for reinstatement to their former position if what's happened is that they've been dismissed or lost their job. There were some instructions from the Labour government to the ERA to consider this as the primary remedy in unjustified dismissal personal grievances. Obviously, the new government has changed that directive, so it's not something that's going to be as common in the ERA anymore, but something to be aware of, that reinstatement is something that you may be looking at. If you have fired someone unfairly, you might have to re-employ them into the business. And lastly, the employee can ask for, or you can be ordered by the Employment Relations Authority to apologise or undertake kind of reconciliatory sort of actions. That might be mediation, it might not mediation, it might be like a mediated discussion to kind of apologise and acknowledge the wrongdoing. But most of the time, what people are concerned about with PGs is the financial cost, and the reinstatement piece, if it's a dismissal one, can be something to keep an eye out for as well. So, in terms of cost, what is it that we're looking at here exactly? So the MB, so the Ministry for Business, Innovation and Employment, which is where mediation services and the Employment Relations Authority kind of sit under, publish data on the compensation that the ERA has ordered employers to make to employees where there has been a successful personal grievance claim. Now, this table does not include costs, and it does not include any claims for lost wages. It's just that compensation component related to hurt and humiliation because the employer did something wrong. Let's have a look at the table. So we can see that there's been, what does that average out to, about 80 employment relations claims where there was a hurt and humiliation payment ordered in the 6 months of the first half of this year. We can see 4 of them were up to about $5,000, 16 up to 10, 14 up to 15,000, and so on. Now, the vast majority of these, the peak of these claims landed in the sort of 15 to 20K sort of value space, with 33 claims at that level. And when we get down to anything more than $30,000, there were only 7 claims that landed in that area. So you can see that most of the time you'll be looking at an award between $5,000 and I'd call it $25,000. That's where the majority of those live. That obviously doesn't take into account your own costs for engaging a lawyer or a representative, taking time out to attend mediation and employment relations hearings, any lost wages that might be awarded, any costs that are awarded to the employee. So this is a rough guide just to give you a sense of what that cost piece looks like for that hurt and humiliation piece. Now, the most recent data I've been able to access on this from the EMA in about 2020, I think, or 2019, said that the average cost to an employer to successfully defend a personal grievance up to the level of the Employment Relations Authority. So hasn't been able to settle it privately, hasn't been resolved at mediation, it's gone to the ERA. Average cost to defend was about $27,000, $28,000. So that's the lawyer's fees, your own time, all that kind of stuff. And the average cost to lose a PG at the Employment Relations Authority was about $68,000. So a difference of about 40K there compared to winning or defending a PG or losing a PG. So $28,000-ish to about $68,000. And this table, again, gives us a sense of what those compensation figures look like. Moving on, we know what the consequences are. We know what a PG is. What happens when you receive one? What's the process? So you do have some legal obligations to meet, and you have some choices about how you want to proceed. The first thing you need to be aware of is you do have a legal obligation to respond within a reasonable time frame. It's not going to be okay for you to ignore this in your emails and hope it goes away. By law, you must respond within a reasonable time frame. As a guideline to our clients, we say about 2 weeks, so about 10 business days. If you have to do anything to investigate the claims, to go back through CCTV footage, to investigate timesheets, any of that kind of stuff, obviously it'll take you a bit longer. I have a friend who raised a PG against his public sector employer, and from raising the PG to getting to mediation took about 12 weeks, so quite a long time in there. But you do need to respond in whatever is a reasonable time frame given the PG and the circumstances. Now, once you've received a PG, again, you have a legal obligation to look into the claims. This might be as straightforward as going back through your emails with them. It could be as complicated as investigating a series of recordings, text messages, timesheets that they've supplied you, alleging that their wages have been underpaid, for example. So again, a bit of a how long is a piece of string question here, but you do have a responsibility to look into their claims. Now, a word on investigations. So in HR and employment law speak, an investigation with a capital I is when we get an external licensed investigator in to investigate a claim or a situation. There will be a terms of reference document, there will be witness statements, there will be the sharing of content among everyone who's involved, there'll be a final report written by the investigator, which states whether those claims can be considered upheld or not upheld. That's an investigation with a capital I. Most of the time, you are not capital I investigating a personal grievance claim. Most of the time, you are investigating it as in looking into it and seeing what you can find to disprove or support the allegations or the claims that they're making. Where it may be appropriate to get an investigator involved is if your company policy obliges you to do so. If you are a larger company with the resources to afford a private investigator, and they're not insignificant hourly rates, if there's going to be significant media blowback from the claims, if it's a massive set of allegations, like if we think about the sexual misconduct and sexual harassment allegations that Ernst & Young were dealing with or are dealing with now, anything of that scale or nature may warrant an external investigator coming in. Most of the time, you won't need one. If you're unsure, seek advice, but most of the time it is okay for you or your business partner or the manager who's involved to look into the allegations and see what they can find. So you've received the PG, you've told them you're looking into it, you've done the looking into it, whether that's capital I investigating or lowercase I investigating. You now have some choices. The first choice is if you have made a mistake or you have done something wrong, you might choose to accept the PG and accept the claims that they've raised with you. You might pay what they've asked for, or you might reinstate them if that's what they've asked for, or you might negotiate on the exact value of the settlement or whatever the compensation is that they're looking for, and resolve it that way. Now, most of the time, businesses don't think they've done anything wrong because no one sets out to try and ruin someone's day or someone's life, right? We're all trying to do the right thing most of the time. So most of the time, accepting a PG is not the first course of action. So often we are disagreeing with the claims that they've raised, and we have some choices about what happens next. So typically what will happen is what we call a first written response to the personal grievance, which will be a letter saying on the 1st of September, we received your PG, we've looked into your claims, here is what we have found. On your first claim of unjustified disadvantage, we don't agree that this allegation can be substantiated. Here are our findings, and here's the emails that we use to support this. For your second claim, and kind of like laying out the response, and then saying kind of, we consider this resolved. Bye, see you later. Now, sometimes the employee or ex-employee will drop it at that point. If it was a bit of a speculative claim, or if they were using an agency like SACT, Kiwi, or any of those no-win, no-fee agencies, as soon as you can show that there was actually a process undertaken for the restructure, or there actually was a process undertaken for the disciplinary process you took them through, which ended on a final written warning, they will back off. It's too hard to argue, and it's not easy enough to win for those no-win, no-fee agencies. But if the employee thinks that they still have an argument, maybe they're not working with a no-win, no-fee lawyer, they might choose to then go to mediation. We'll talk about mediation in a second, or they might choose to take their personal grievance straight to the Employment Relations Authority. So you are not necessarily in control of what happens next. But obviously, if you don't want to go to mediation or don't want to go to the Employment Relations Authority, at any point in time, you can accept the claim and choose to settle. Settling doesn't necessarily mean you are agreeing that there has been wrongdoing happening, but sometimes your time is worth more to you than your money, so you're willing to pay some go-away money just so you don't have to deal with the headache of a PG claim, going to mediation and all the rest. So, a PG has been raised, maybe you've written back to say, I don't agree with your claims here, they can't be substantiated. What is likely to happen next is you may get an invitation to mediation, which is the next kind of escalation point in the process here. So mediation is a voluntary, confidential process, voluntary with an asterisk, we'll talk about that a bit later. And what happens is a private or a public mediator will get involved to try and resolve the problem between the parties, whether that problem is that they think they've been fired unjustifiably, whether they were disadvantaged by the way that the kind of leftover jobs in a restructure were assigned. Whatever the claim is, the mediator is a neutral third party to try and help you work it out. Now, you can pay a private mediator, that's totally fine. Otherwise, MB offers mediation services where you can get access to a mediator for free. I've used them in the past, both personally and professionally, and supported friends there. The MB option is very good. The team are very capable and qualified. The only kind of hang up is it may take you some time to get in front of a mediator because they're a public service and so they're quite busy. So the role of a mediator is not to say Sylvie is right and the employee is wrong. Their role is to try and get the parties to agree on an outcome that is acceptable to both of them. That outcome might be reinstatement, probably not to the employer most of the time. The outcome might be a payment made to the employee to acknowledge the cost of whatever's gone down. Or if an outcome can't be reached, they can help guide you on next steps. The mediator does have opinions, right? So if an employee is asking for $50,000 because they disagreed with how a promotion opportunity was handled. If we look back at that table, there was only one claim, I think, so far this year where the award was above $50,000. So the mediator is going to say to the employee, I don't think you're going to get 50. I think that's an unreasonable thing to be asking for. If you want to be asking for it, I can try and help you get there. But my feedback or my guidance to you is I think you're going to have to come down on that figure. Where kind of would you be comfortable with? Where can we get you to? So the mediator will have opinions, but again, they're not there to say Sylvie was right and the employee was wrong. They're there to try and help facilitate the conversation and be an impartial third party to get you to an outcome where you can both kind of move forward. Now, at the end of mediation, any agreed outcomes will be written down and become binding. Typically, this is managed with something called a record of settlement document, which we'll look at in a couple of slides. But just a heads up that mediation isn't binding. If you suggest something and it's knocked back, you're not going to be held to account for that. Equally, if you don't reach an outcome, that's totally fine. Mediation hasn't failed. You just haven't been able to reach an outcome with that employee. Now, a caveat to that is that if you want to, the employer and the employee can agree that the mediator will have the power to make a binding decision. At the end of all of the back and forth and all of the negotiating, you can agree that the mediator can say, look, I think this claim for $50,000 is outrageous, but I do think there were some flaws in the process. So I'm ordering a payment of $5,000 be made to the employee to compensate them for the disadvantage they experienced when that promotion was managed. It's not very common. I've never seen it happen. So most of the time mediation isn't binding, but you can hand over that power if you want to. Now, a quick word on the fact that mediation is intended to be voluntary. So if an employee raises a personal grievance with the Employment Relations Authority, so the first kind of binding decision-making body in this hierarchy of options, and if you haven't been to mediation, the authority member is likely to direct you to try mediation first before they will agree to hear the case. They won't do that where the circumstances aren't appropriate. Typically that's to do with sexual or racial harassment, or if the employee is alleging bullying by the business owner or the person involved. So sometimes skipping mediation and going to the ERA is appropriate. However, most of the time, if you haven't tried mediation, you'll get directed there first. So voluntary, but it is encouraged as a tool before you get to the ERA. In terms of the process, what to expect, first thing that will happen, whether you're doing this in person or over Zoom, is the mediator will meet with each party separately. So you're either in separate physical rooms or you're in separate virtual rooms, depending, to introduce themselves, explain how the day will go, give you a bit of context and let you know what to expect. So you meet separately. Then they will bring you both together in one space to share your opening statements, kind of share your perspective and start the process off. So that's called being in a caucus, you're all together. Then typically what will happen is the mediator will take turns meeting with each party separately to negotiate, make recommendations and see if they can move discussions forward. Depending on what's being discussed, the parties do come together and separate as the day goes on. What that looks like, again, is a bit hard to say because it depends on what's being discussed, but there will be plenty of time where you're hanging out separately from the other party and then you come back together to discuss or agree or negotiate where you need to. Again, agreed outcomes will be documented and signed by both parties, or if there aren't any agreed outcomes, the next escalation point is the Employment Relations Authority. So let's talk about the ERA. We are flying through and doing well for time, so good work, everyone. Now, unlike mediation, the ERA can make binding binding decisions on what the outcome is. So what will happen is the employee typically will send through to the Employment Relations Authority a statement of problem. This is the document which says, what is the situation as you understand it? What happened? What evidence do you have to support this? What's the outcome you're looking for? And then the responding party, normally the employer, will have a statement of response that they will send through, which is their side of the story. The authority member will have a look through both of those. They might ask some questions depending on what it is. And then a hearing is scheduled and happens where the authority member gets everyone in a room and asks questions of both parties as they need to try and understand what happened here and what the issue was. Once the hearing has wrapped, they will consider all information and issue a determination which says, no, the employer has done nothing wrong. I don't consider the PG has been upheld. Or yes, the employer has done something wrong. The employee needs to be awarded $15,000 in compensation plus costs or whatever it is. Now, once you've got a ruling from the ERA, that can be appealed to the Employment Court or the Court of Appeal. The Court of Appeal one is a bit technical kind of legally, so I won't go into that one. Basically, you probably will be able to appeal to the Employment Court. Appealing to the Court of Appeal is a little bit different, but again, given the costs and the effort and time involved, most people don't go beyond an Employment Relations Authority outcome. Okay. I've mentioned record of settlements a few times. Let's talk about what it is that they are and what they look like. This is a legal document which captures agreed outcomes, typically at the end of an employment relationship. This could be whether you are paying them an extended notice period, for example, as part of a negotiation. It could govern when the property is being returned. It could capture payment for hurt and humiliation payments under Section 123 of the Employment Relations Act. Whatever is agreed between the parties gets captured in a record of settlement. And a sample one looks like this. So looks like a reasonably legal document, as you can see. It's a sample one, so obviously I haven't filled out the details in red. But the two key things to note about a record of settlement are, firstly, that once one has been signed, there is no take backsies from either party. It is pretty ironclad in terms of saying, we have settled everything there is between us. The employer can't come after the employee for anything else, like deductions to their wages for property that was damaged. The employee can't come back with a PG for something related to what we've settled. This is done and dusted. It is over and done. So getting a record of settlement in place obviously is attractive to employers because it means that the issues are resolved. It's obviously attractive to employees because it means that they can kind of move on with their life and often involves some kind of payment. Now, the other thing to be aware of is that Section 123 of the Employment Relations Act allows for payments for hurt and humiliation to be made tax-free. They are not earnings, so they are not taxed under kind of PAYE like income normally is. It is a compensatory payment for something that the employer has done wrong, and the employee is not taxed on them. What this means is you can start getting quite creative about how you package up a record of settlement offer to an employee so that they get more money than they normally would if they had this payment made to them as normal earnings. And it means that the cost to the business will be a bit less. We're not trying to avoid tax. Tax evasion is illegal. I'm absolutely not recommending that. But when we think about things like redundancy compensation, when we think about things like otherwise extending a notice period, sometimes those offers can be made under Section 123 in order to make it more attractive to the employee because you're not paying it through payroll like you normally are, while also keeping the cost of the business a bit less than you otherwise might need to. So, when do we want to use a record of settlement? Now, in addition to being potentially the outcome for a PG claim or for a mediation process, they can also be a proactive tool to avoid a personal grievance being raised. So if you've run a dodgy restructure process, or if you've fired someone on very, very skinny grounds that probably wouldn't withstand a lawyer looking at them, this can be a way to pay some money now to avoid the headache of a PG and paying lots of money later. Now, sometimes businesses say paying any money to this employee, to this Yahoo who is a terrible person, is not acceptable to me. I don't want to countenance this. Totally fine. You can take your risks with a PG and see what comes back. But if you're going to go, actually, maybe I was a bit sneaky in the way that I managed this termination process, for example, I would much rather pay a couple of grand now and know that this is done and dusted forever than have this lingering over me for the next 90 days and potentially the next 3 years. As an example, if at the end of a restructure you have taken shortcuts with the process, if this has been a bit of a sham restructure process to get rid of someone who you don't like, which means the restructure hasn't been to do with the commercial viability of the job, it's actually about the person, which is not allowed in restructuring, as you will know if you've seen any of our content to do with restructuring. You might offer to pay someone 2 weeks' earnings as redundancy compensation, assuming they're not otherwise entitled to it. Most employees aren't in New Zealand at the moment. You might say to someone, look, I totally appreciate this has been stressful. I really recognize this has been difficult and that you're out of a job. Would you consider accepting 2 weeks redundancy compensation? I can pay it to you tax-free, conditional on you signing a record of settlement document. What this means is you can't come back at me, I can't come back at you, but what it would do is it would give me a way to pay you 2 weeks of your earnings tax-free, which is a 35 to 45% bump, and it means that we just kind of resolve this and have it done and dusted. Now, most employees staring down the barrel of redundancy will happily take additional compensation, and if you are offering extra compensation, you may as well get a record of settlement in place to protect you against any future personal grievances. So that would be one example of where you might want to use it. Or alternatively, if you run, or as another example, I should say, if you have run a disciplinary process and you have ended this person's employment by way of summary dismissal, so they're not entitled to their notice period, right, because you're calling it serious misconduct, which means no notice period, you can say, look, I regret the circumstances that have kind of led us here, to recognise your years of good service or whatever it is. We are offering to pay your notice period under Section 123. this would mean it's tax-free, but it's conditional on signing a record of settlement. So the story that you're telling is you are being a good, generous employer and inviting them to accept additional payment in acknowledge of this, subject to signing a record of settlement piece. The story actually is you've run a bit of a dodgy process and you want to cover yourself. We're obviously not going to tell that story to the employee. But in terms of how you manage this discussion, you can see how you would be able to get quite creative in terms of getting a record of settlement across the line to avoid a headache down the line with the trade-off being a bit of a payment now. So having looked at all of that, let's now talk about ways to minimize the risk of a PG, because it's impossible to avoid them. You can't stop employees raising a PG, but there are certainly things that you can do to reduce the risk of getting one. And the first thing to do is to always consult with your employees when you're making significant changes to their employment. Even if the reason you're making the change is fully justified, let's say that your sales have reduced by 40%, so you have to reduce your headcount by 40%. That's fair, right? No one would say that's an unreasonable business decision. Legally, you have to have a good reason for the change, which you do. You also then have to go through a fair process to implement that change. So always make sure you're going through a consultation process if you are making changes to your people's employment, even if it's not redundancy, if it's a big change otherwise, make sure you consult in the first instance. Second thing you want to do is make sure your employment documents have been at some stage reviewed by a professional, ideally every 3 to 4 years, given how quickly some of the law can change, and make sure they're up to date. So make sure your employment agreements, variation letters, any of that kind of stuff is up to date and nice and tidy so that you don't have employees potentially raising a PG because your IEA doesn't meet those legal requirements I flagged earlier. Again, make fair and reasonable decisions regarding your staff. Fair and reasonable, as with so many things in employment law, is a very flexible threshold to meet, right? But basically, if someone on the street would think you were being unreasonable, for example, if you wanted to fire someone because they had been late to work 3 times, unless they're an anaesthetist or a surgeon and their being late like killed someone or ran a very serious health and safety risk, most of the time it won't be fair to fire someone because they're late 3 times. So make fair and reasonable decisions. Again, bounce your ideas or bounce what you want to do off someone if you need to. But if you're making fair and reasonable decisions, again, that will be another step to protect you against a claim for unjustified disadvantage or unjustified action on your behalf. Goes without saying, don't bully, harass, or discriminate against your workers. Be aware of the different grounds for discrimination in the Human Rights Act. If you Google Human Rights Act, you'll be able to pull it up. And make sure your managers behave professionally within the law too. Especially as your business grows, it's not always possible for you to be exactly across what all of your managers are doing at all times. So adequate training, making sure they understand the law, making sure if they want to discipline someone or do anything to do with employment changes, that you're across it as well, so you can make sure everything's legal, becomes really important, especially as you get bigger and can't see what's happening all the time. If you are unsure about running a process or making a change or having a tough conversation with someone about their performance or their behaviour at work, do seek advice. You might have an employment lawyer available. If you're a MyHR client, you can call us anytime free of charge. We're happy to have a conversation and talk you through it, but do make sure you get advice. It's a lot easier to avoid making poor decisions at the beginning of a process, even if you don't think it's a poor decision, it might be, than it is to unpick them and defend them later on. So front load your prep for the trial period termination or the termination for medical incapacity or the restructure. Do as much work up front as you can so you don't end up having to unpick sticky situations later down the line. I think I hammered this point home, but especially if you're considering ending someone's employment, to make sure you're seeking advice on that process. Now, to give you a sense of the stats here, how common are PGs? How often do we see them? So in New Zealand, we have 1,400 businesses that we support, and that's about 35,000, I think it was 35,000 this morning, employees under our management and under our support that we provide to our businesses. So in a month, we are doing 140 disciplinaries for our clients. So that's everything from poor performance to misconduct to serious misconduct resulting in termination. And we're doing about 111 restructures a month. So changing people's employment either permanently or temporary or making them redundant depending on the circumstances. So that's 250 odd kind of disciplinaries and restructures. This data doesn't include things like trial period terminations or other terminations. It's just disciplinaries and restructures. And we get 2 personal grievances a month on average. So less than 1% of the consultation processes that we support our clients with result in a PG. They're not actually as common as you think they might be. Certainly if you're running a process that isn't documented or that is super loose and super unprofessional, your chances of a PG inevitably will increase. But because we are giving our clients documents, they're going through a fair and reasonable process, we're helping them sense check, any kind of speculative PGs tend to be headed off at the pass because the person looking at it knows that there's been a process involved. So less than 1% of what we get involved in a managed results in a PG. Now, in addition, we have about 3 to 4 without prejudice conversations or records of settlement a month. That's where we have spotted a risk for the client and potentially we may need to manage that risk with them. That's a proactive action that we're taking to avoid the risk of a PG. If we weren't doing that with our clients, you might be seeing 5 to 6 PGs a month, which takes us up to about 1.5% of these processes result in a PG, but it's not a kind of massive absolute increase. So just to give you a sense of how common they are. Coming to the end now, we're at 1:47 p.m, so plenty of time for questions, hopefully. In terms of bonus resources, you'll get the slides and recording, as I mentioned earlier. You'll also get a personal grievance process map that we've prepared, which shows you what to expect at each stage and what might happen as you get to the end of that process. And then there is also a complimentary 20-minute consultation option with me. If you're a MyHR client, I've been around a long time, you probably know me. If you're not a MyHR client, you are very welcome to book some time in to talk through a situation further. It's not a hard sell. I'm not going to push you to sign up to our mailing list or anything. But if there is an opportunity for us to support you, I might invite you to have a conversation with one of our solutions teams. Thank you. That is all of my content today. We got through that in very good time, so thanks everyone. Let's jump into questions and I will just minimize my screen so I can be seeing all of you in a bit more detail so that I'm not a tiny head answering your questions. Cool. Let's see what has come through. Anonymous asks, is the presentation available after the sessions? I can only stay for a short time. Yes, it is. You'll get a link to it in the follow-up email, which will probably go out tomorrow afternoon or Friday morning, and also a link to the slides as well. So you'll be able to see all of those. What is the threshold for a hurt and humiliation claim? I imagine there's a large spectrum of examples. That's exactly right. Hurt and humiliation doesn't require an employee to share notes from their psychologist saying that they've been damaged and hurt by the actions at work. It's basically it's a label for the payment you can be ordered to make to acknowledge that you've done something wrong, basically. It would be really hard to give you a threshold because there can be so many examples. But if you fire an employee with no process, if you don't give them a fair chance to apply for a role that they thought they were a good fit for during a restructure, if you change their hours of work quite significantly without consultation, anything where you've done something that is unreasonable may result in a hurt and humiliation payment. I can pull up those numbers again in terms of how common those payments are within those bands. But yeah, basically, if you've done something unjustified or unfair to the employee, you may be on the line for a hurt and humiliation payment if a PG comes through or if it goes to the ERA. Anonymous asks, with regards to potential consequences, financial or otherwise, what about the notice period due to the employee? In this specific case, it's 3 months, which is quite significant. So in most circumstances, if an employer terminates the employment of the employee, so the employer has made a decision not to employ them anymore, then that person is entitled to their notice period, the payment for their notice period. So the exceptions to that would be if there is a trial period where you have a shorter notice period agreed. If their employment ends as a result of the trial period, it might be 1 week, not 4. If they are medically incapable of doing the job, say they were in a significant car crash and they work in retail and they've broken both their legs and can't return to work for 6 months, You may not have to pay them their notice period because they can't work it, right? So you're not compensating for them for anything that they're losing. Or if you take them through a termination process for serious misconduct, which is something where the employee has behaved so badly and so broken trust and confidence in the relationship that they have forfeited their right to their notice period, basically. You don't have to pay them their notice period in that circumstances. But in most other ones, whether it's termination for kind of ongoing poor performance, if it's termination at the end of a restructure, if it's, what else would you have? Kind of any other reason you might be having them move on, you will need to pay them their notice period. So in terms of not having to pay a notice period, there are some circumstances. In most circumstances, you will need to pay it. And so you'll need to factor that into your calculations when you're figuring out, is it worth moving this person on or is it not? Cool. Anonymous asks, please can you talk about where lawyers send, what happens when lawyers send two letters? One is without prejudice and one is without prejudice. So one is without prejudice, the other one says nothing. So I don't know why a lawyer might choose to do that. Without prejudice means nothing said by either party can be used against the other party in future. Mediation, for example, is a without prejudice environment because you want to be able to have kind of real, honest conversations with each other. Yeah, I'm not super clear what the strategy would be there. I guess it might be to have the on-the-record communication look a certain way, perhaps look like the employee is fully prepared to defend their claim to the ends of the earth. And the without prejudice communication is about saying, well, let's be realistic here, the employee will settle if the offer on the table is right. So maybe that could be a reason. Yeah, I'm not super clear why they would send two letters at the same time with kind of different conditions attached. That doesn't, I can't quite see the logic behind that strategy, I'm sorry. Vic asks, I've previously been told if you want to make a Section 123 payment, you have to raise a PG for this to be valid, otherwise a tax-free payment can't be made. Is this true? No, that's not true. You can make a Section 123 payment as long as it's called and appears to be a payment from the employer to the employee for hurt and humiliation. You can sign a Section 123 payment off at the end of a restructure, at the end of a disciplinary, as part of a without prejudice agreement to exit. So you don't have to have a valid PG in place to sign off on a 123. Cheryl asks, and actually my laptop battery is about to die, so while I answer this question, I will just get myself sorted with the charge of the laptop. So Cheryl asks, can you take a PG against the employer you are still employed by, using the example of an employee missing out on a promotion? So yes, you can raise a PG against your current employer. You don't have to be an ex-employee to raise a PG. If you genuinely believe you have been disadvantaged by the employer's choice in how they manage the process, you might have grounds for a PG there. If you just, as an employee, feel a bit disappointed, that's not going to be a good reason to raise a PG. But yes, the short answer is you can raise one against an employer while you're still employed by that employer. Craig asks, do records of settlement have to be signed off by a mediator to be valid? Great question. No, they don't. So you can sign off on a record of settlement privately with an employee without getting a mediator involved. However, the reason you may want to lodge one with mediation services is they keep a record of all of these documents. And so if the employee tries to raise a claim later, they will search up their database and see a record of settlement is here for this employee and this employer and prevent them from taking it further. So it's a bit of a protection mechanism, but no, they don't have to be signed by a mediator to be binding. Anonymous asks, we received a request for mediation from an ex-staff member through MB. Then on the same day, received a notification from MB that the request for mediation was withdrawn and we were advised the case was closed. Can this ex-employee still raise a PG? It was 2.5 months ago that the emails were received. So the employee can raise a PG regardless of those mediation back and forth emails within 90 days of the thing occurring that they are raising a PG about. or within 12 months if it's a sexual harassment claim. So without knowing the timeline of what might have happened to have this employee think there might be a PG, I can't answer that question. But the short answer is disregard those emails from MB in the timeline of when does the employee's time run out. You're looking at that 90-day clock or that 12-month clock, depending on the nature of the claim. Cool. Also, Vic asks, any advice on getting an executive leadership team to understand that getting a PG, while not ideal, isn't the end of the world? And if staff are hinting at it, we can still carry on with whatever process we're doing without backing down and being walked all over. It's a really good one, Vic. It would be interesting to lay out the consequences and next steps for a PG to your executive leadership team to see what it is they're so afraid of. PGs are managed privately, so they don't go in the press unless something really drastic or bad has happened. That can take a long time to resolve them, so you don't have to make on-the-fly kind of urgent defensive decisions. You have many opportunities to negotiate an end to the PG before it gets to mediation, the Employment Relations Authority, and especially if there is in-house HR, it pretty much becomes that person's job to coordinate the outcome. So I wonder if you could say to them something along the lines of, what I'm observing is that there is a real reluctance or a lack of appetite among the leadership team to receive a personal grievance. To my mind, this is a risk to manage, but it's not the end of the world if we do get one. I'd love to understand what your reasons are for being so reluctant to run the risk of a PG. Kind of, can I understand where your fears are coming from? And it could just be a misunderstanding about what a PG is and what the consequences are. Or it could be that they've been badly burned once before and kind of just a traumatized by that experience and don't want to go through it again. Once you understand what the problem is, you can kind of manage a response based on that. But typically, once you demystify the process, people become a bit more comfortable with it. And also understanding that receiving a PG doesn't mean you're going to lose money. You might lose some time responding to it and telling them to piss off because you totally followed a fair process. But yeah, depending on what the hesitation is, I think will depend on what will affect what your response to that is. But yeah, it can be a bit of a tricky one. Anonymous asks, does a 90-day time frame for an employee to raise a PG count from the last day of work or last day of employment? It counts from the day that the bad thing happened that they're raising a personal grievance for. So if they were dismissed on notice, it would be, I believe, the last day of employment would be the countdown of their 90-day time frame. If they missed out on a promotion, it would be the day that that outcome was confirmed. So it's from whenever the bad thing happened that they are raising a claim for. Would it be reasonable, question from Anonymous, to try and get a record of settlement if the employee has asked to resign in lieu of being terminated after a robust process? I think so. I mean, getting a record of settlement never hurts because it means that you know there is no comeback or blowback from the employee. So I would agree that getting a record of settlement signed there would be sensible. In terms of what you might offer the employee, you might offer them the option to say that they resigned rather than were fired or were made redundant. Sometimes it's very important to people to be able to say that they left on their own terms rather than were made redundant or were fired, as you might imagine. So you might want to do some negotiating around what is in the document, but yes, I would think it would be reasonable to get an ROS signed in those circumstances. Cool. Anonymous asks, and actually we're at 2 p.m. now, so I'll just check in with everyone. We still have 96 people on the call, which is awesome. Thank you so much for bearing with us this long. I will stick around for 15 more minutes and get through as many questions as I can. So you are welcome to duck out at this stage if you have other things to go to, and you'll get a copy of this recording afterwards again. So thank you for joining us if that's the case. Otherwise, you are super welcome to stick around. I'll keep going through questions and then we'll wrap up again in 15 minutes. So up to you. Can the personal grievance claim include both lost wages and notice period, or can it only include the lost wages? This is post an employee being summarily dismissed. The PG claim can include as many things as the employee wants to claim for. Whether it's reasonable for them to do so is something different. So if they were summarily dismissed, which means no notice period, and their PG is that they were unfairly dismissed, if I was advising the employee, I would say to claim for lost wages and the notice period they should have been entitled to because they were dismissed without it, when any dismissal should have included the notice period because it wasn't fair they were dismissed in the first place. So a PG can include anything. They could ask for a diamond necklace if they wanted to. There's no limit to what an employee can ask for. But if I was advising this particular employee at the end of a summary dismissal process, I would say to be claiming for the notice period or to be trying to negotiate to get their notice period paid out to them. Anonymous asks, once a record of settlement has been signed by both parties and lodged with MB, what happens next? Does a mediator contact each party? Yeah, that's right. A mediator will call each party to check that they understand what it is that they've signed, that they are clear on what they've agreed to, and there aren't any questions left. Then once they've checked in with both parties, they will sign it. I think there's an email that you get which says that your ROS has been signed and lodged. So yes, there is a phone call that goes out to both parties. Anonymous asks, can the employer be forced to attend the mediation meeting even though they refuse? Even though the employer doesn't want to go, or go straight to the ERA as a last resort. So no one can be required to attend mediation. The Employment Relations Authority can say, we are directing you to attend mediation before we'll hear this case. But if one or both parties refuse, the next step is to go to the ERA. So you can refuse to attend mediation. It is a bit of a black mark against you when it gets to the ERA, because they'll say, well, you clearly aren't trying to resolve this problem. So you start off on the back foot a bit. But yes, you can refuse to attend mediation, and ultimately your claim, the claim might go straight to the ERA. Can the IRD challenge a Section 123 payment? Yes, they can. So what will happen most of the time is if a mediator looks over the record of settlement and they think there's some tax evasion going on, they can give you that advice and or refuse to sign it because they think that there's a tax evasion thing happening. That doesn't happen super often, but it does happen. And or if you don't get it signed by a mediator and this employee gets a lump sum payment of $20,000, the IRD might inquire about that payment and check it was all above board. And if they don't agree that it was managed appropriately, then yes, the IRD can get involved. Anonymous asks, what are the maximum months that lost wages can be claimed for within the 3-year period of bringing the PG to the ERA? The entire time. So if the employee was terminated in, let's call it 2020, at the end of 2020, they raised a PG within 90 days, then they submitted their claim to the Employment Relations Authority at the end of that 3-year period, and then it took another 6 months to get in front of the Employment Relations Authority. That's 3 years and 9 months of time between them being dismissed and getting in front of the ERA. If they have been unable to work for that entire 3 years and 9 month period, and they can show that it is because they were terminated and potentially that was so traumatizing and stressful that they haven't been able to return to work, potentially the ERA can order lost wages be paid for that entire 3-year and 9 month period. Now, there would be a bit of an onus on the employee to prove that the reason they haven't been earning is because of this dismissal. So they would probably at that point need to supply psychologist or psychiatrist reports saying that they've been so affected by it they haven't been able to work. So the burden of proof changes a little bit in those circumstances, but potentially the entire time. There's no cap on the amount of time for lost wages. Leslie asks, what happens with a record of settlement that's agreed and been signed when the ex-employee goes on to malign the employer and talk about what's happened publicly and negatively is the only recourse through court? So most records of settlement, certainly any ones that we would prepare, say that neither party can badmouth the other, and if the terms of the record of settlement are breached, that either party can pursue the other to have it kind of repaid or to have the breach of the record of settlement compensated for. So if a record of settlement has been signed and the employee is breaching the terms of the settlement, what you would do then is apply to the Employment Relations Authority for what's called an injunction, like an order, to the employee to pay back the monies that have been paid back to them under the record of settlement. There are plenty of examples of this happening. Typically, the employee gets a bit cocky and talks about it on social media and goes, "Wow, I took on my employers, screw those guys, I got a payment and rah-de-rah-de-rah." And then the employee is ordered to pay it all back. So the short answer is you do have recourse, but yes, you do need to go through the Employment Relations Authority for an injunction to require the employee to pay it back. Anonymous asks, does an employee need to say, "I'm raising a personal grievance," or is formally directly telling the employer about the complaint considered a PG? They don't need to use the exact words, "I'm raising a personal grievance," but they do need to make it clear what the complaint is, why they have grounds for a complaint, and the fact that it relates to their employment. So saying, "I'm grumpy about Sylvie's behaviour towards me" is not a PG, right? That's just an employee having a complaint. Or if they say, "I'm raising a formal complaint about the way I was treated, rah-de-rah-de-rah," that probably also isn't a PG because they've used the word complaint, they're calling it something else. So it is a bit of a grey area how explicit an employee needs to be in raising a personal grievance with an employer. The obvious kind of solution is to go back and say, "To clarify, we've received your email or your text. Would you like this to be treated as a complaint, formally, informally, as a personal grievance? Kind of how would you like this to be resolved?" And then they can then clarify for you. But the short answer is they don't have to say, "I'm raising a PG." What counts as a PG then gets a bit grey and depends a bit on the circumstances. Donna asks, Donna, thanks for coming along. An employee gives an exit interview feedback about his manager. Employee resigns and then sends a PG about his complaint not being investigated. However, the exit feedback was investigated but was not shared with the employee because the employee left and it wasn't perceived as a complaint. What is our obligation in investigating such exit feedback? So you totally did the right thing in looking into the feedback. Great job, you've done what's required. Even if the employee had then left, I would have recommended in those circumstances that you reach out to the employee and say, "Hey, we received your exit interview feedback. We've looked into your comments about so-and-so. We have determined kind of there's nothing further to look into here, but again, appreciate you raising them with us." Just a communication to wrap up the process, even if the outcome is, there is no outcome because we investigated and kind of nothing needs to be done. So I would say that you've met your obligations to look into it. I don't know what the PG would be for. I guess unjustified disadvantage, maybe. Yeah, I can't think what their clear line of argument there would be. But I on the information shared with me here, I don't think that PG would have legs. Anonymous asks, can locums raise a PG? They don't have a contract or anything. Great question. So the short answer is it depends. The long answer is an employee that's in a triangular employment relationship can raise a PG against their controlling employer. So where you have an employee who works for a labour hire firm, like basically kind of temps who are employed by a deco and who come into site for 2 days to help out with something, even though they're employed by the hire agency, the labour hire agency, they can raise a PG against the controlling employer, so the one that they were doing work for every day or every week, for any of those grounds. So if your locums are in a triangular employment relationship with the agency that supplies them and then the practice or the clinic that employs them, then yes, they can raise a PG against the clinic or the practice as the controlling employer. Cool. Great answers as always. Thank you, Sylvie. Oh, you're welcome, team. No problem at all. Anonymous asks, just wanted to confirm, we went to mediation with a current employee over a PIP, but we left mediation with that issue unresolved. They have since resigned. Do they have 3 years to reopen the PIP PG with the ERA? It depends whether there was a PG in the first place. So if the employee said, I'm raising a PG for unjustified disadvantage, I don't think this PIP is fair and it disadvantages me in XYZ ways. And then you went to mediation and it was unresolved and the employees left. Yes, they have 3 years to raise it in the ERA. But if there was no formal personal grievance in place, but you went to mediation to try and resolve the issue because you were at your friggin' wit's end with this person and just needed some help to try and get them across the line. If there was no PG already in place, then they've got 90 days from the PIP being kind of issued to raise a PG. And if they miss that window, there's no 3-year time frame because there hasn't been a PG established to hang the 3 years off, if that makes sense. Scrolling down. Last couple here, then we'll wrap up. If we have done a PIP with an employee and before the final session, the person resigned because they found new work, we continued with the final session, but it was more about a discussion of learnings than about a PIP necessarily. Is there a chance for a personal grievance from this person? There's always a chance of a personal grievance from people. We can't remove people's right to bring a PG against us. What I would say is that potentially they might have a PG for unjustified disadvantage due to constructive dismissal, basically where as the employer, you make it so awful for them that there's no way they could stick around because you're being so terrible to them and it's disastrous. That threshold is quite high. Just putting someone on a PIP wouldn't meet that, but that might be an argument they could take. Alternatively, if they thought that the PIP was massively unfair and disadvantaged them in some way, they might have grounds to think about an unjustified disadvantage PG. But again, it's the short answer is yes, there is a chance. Given that they've found new work and are kind of moving on with their life, maybe not likely for them to be raising a claim, but it's hard to say without knowing the person and knowing how litigious they are. Cool, I'm just going to check through. There are a couple of comments here which weren't questions, so I'm just going to go back through and have a look and see if there's anything in here that I missed. I answered that one. Last question here. How do we legally manage a redundancy process when a job was newly created and the person did not end up being as busy as expected? The issue is that the manager did not engage in any job sizing activity when getting approval. HR was also brought in. That's a longer question that maybe isn't as on topic for a PG webinar. So that's a great question and I do have a response, but just to make sure I'm kind of being respectful of everyone's time, I'd suggest you book in some time with me to talk that through. You'll have a copy to the link to book some time in my calendar towards the end. But great question, thank you for sharing. And yeah, hopefully you and I can have a conversation about that in more detail later. Cool. Last question here. Anonymous asks, if someone doesn't turn up to MB mediation stating they're in hospital, can we request a medical certificate as confirmation? If they are still an employee, you may be able to, depending on a few things. If they are an ex-employee, no, you can't request a medical certificate. You can rebook the mediation date, but if they're not an employee, you don't have any legal reason to be asking for medical information. I appreciate that you want proof that they aren't just skiving off and missing the meeting, but medical information is confidential to patients and employers have some right to view it because it affects kind of work and health and safety. But if you're not their employer anymore, you don't have a right to ask for their medical certificate, I'm sorry to say. Cool. That was everything. Thank you, everyone. We're at 2:14, so just coming in under the additional time. So thank you for sticking around today. I trust that was useful. There was a lot of content that we covered, and if you do have any questions, feel free to get in touch. Otherwise, I will let you go back to your Wednesdays and say thank you again for joining us and looking forward to seeing you at the next one. So have a wonderful afternoon, and I'll speak to you again soon.